Okay, there's exceptions, just like anything, and there's exceptions to these transfer rules. Not every gift results in a penalty. There's a group of exceptions that have to do with the home because it's the biggest asset for most people. So if you transfer your house to your healthy spouse, there's no penalty. And in New Jersey, there's no lien that's put on the house because it's not in the name of the spouse who's receiving Medicaid. So, you leave, people go in and apply for Medicaid all the time and they'll say, oh, the house is exempt. And it's in two people's names, the husband and wife. And they leave it in the two people's names because the house is exempt, not realizing that after the ill spouse passes away, Medicaid has the right to put a lien on the house for the amount of money that was paid to support the ill spouse in the nursing home. That happens a lot in our state. All you have to do to preserve the house for the spouse and the children or other loved ones is to transfer the house into the name of healthy spouse. And they never put a lien on the healthy spouse's assets, just on the ill spouse's assets. But you'd be surprised how many times that very easy transfer is not made. Okay, number two, if you have a child under age 21 or a blind or disabled child, you can transfer the house to one of those children and it's an exempt transfer, it will not result in a penalty. If you were living with a sibling, your parent passes away, they leave you both their children equal interest in the house, and one of the siblings gets sick, they could transfer, and you were both living there for at least a year. The ill sibling can transfer the house to the healthy sibling with no transfer penalty. Or again, that comes up, but not that often, but it does come up. This caregiver child exception comes up quite a bit, where you have a child who has moved into the parent's house and living with the parent and caring for the parent. And if you've done that for at least 2 years, then the parent could transfer the house to the caregiver child. It's become, it was at one time it was very straightforward. Now you have to produce all medical records and show the kind of care that the caregiver child provided to the parent, but it still works. You can still transfer the house to these caregiver children as long as, they meet the criteria. They have to need a nursing home level of care, basically. They have to be unable to perform three activities of daily living, like I was saying, or have a cognitive impairment. If they do, the house is exempt once it's transferred. Or assets other than the home. So you can transfer assets to the community spouse. You can transfer assets to a trust for the sole benefit of the community spouse. You can transfer assets to a minor, blind, or disabled child. Again, these are transfers that do not result in a penalty. You can transfer assets to a trust for the sole benefit of a minor, blind, or disabled child. So, transfer assets of a disabled beneficiary to a trust for the sole benefit of the disabled applicant. In other words, you can transfer assets to a trust for the disabled person who's applying for Medicaid. If you have a trust established for a nonprofit association, or if you can prove that assets were transferred for a purpose other than to qualify for Medicaid. That's a tough one. But we did have, all these years I've been practicing, I've had one case where I was able to show that assets were transferred for a purpose other than to qualify for Medicaid. They want to see all the medical records of the applicant to show, because I say the person was sick, obviously they were going to be transferring it to qualify. So, it's hard to prove, but sometimes it's true. They're transferred and it's a sudden illness that happened, traumatic onset. And if you can show that the assets are transferred for a reason other than qualify for Medicaid, then the transfer is exempt. Okay, so here's some other rules that are important for married couples. So you have a married couple, an ill spouse and a healthy spouse, okay? The income of the ill spouse, that's all going to go to Medicaid or the facility. But the income of the community spouse, it's another name for the healthy spouse. The spouse is going to continue living in the community. That income is exempt. You know, you don't have to worry about whatever the healthy spouse received is the healthy spouse is able to keep. And there's no, the Medicaid will never take it and will not disqualify anybody for Medicaid. Okay, MIMNA, the minimum monthly maintenance needs allowance. This year, it's 37.15.50 in our state. In other words, you have a healthy spouse and an ill spouse. Sometimes the ill spouse is receiving a lot of income and the healthy spouse is not. And they were living on, it's a couple, and they're living on the combined income. So if the ill spouse goes into the nursing home, usually you have to pay over all the income to the facility or return it to Medicaid. But if let's say the healthy spouse is making $1,000 a month in Social Security or whatever, the minimum amount that they'll get is this 37.15.50. In other words, Medicaid will allocate income paid to the ill spouse to bring the income of the healthy spouse up to the minimum amount. So the facilities don't get all of the income. The sum is returned to the community spouse, so the community spouse can continue living in the community. You have to have income to do that. This is another thing, excess shelter allowance. There's a list of items that constitute the shelter costs, and to the extent that the shelter expenses exceed 686.63 a month, you can get money from the income of the ill spouse to cover that. And then this is a big thing, the Community Spouse Resource Allowance, they call it CSRA. It's one half of the countable assets, but there's limitations. So for example, the couple has $600,000, for example, in cash or IRAs. And I said, the ill spouse has to spend down to $2,000, but the community spouse, they're going to continue to live in the community. They can't live on $2,000. So they have this resource allowance. If your total assets are, let's say, $200,000, you get to keep 100, one half of the countable assets. But if your total assets, let's say, are 600,000, there's a maximum. You can only keep $148,620 of it. So you can just keep that. That doesn't require any kind of planning. You keep $148,620. It's everything else above that. Medicaid calls the spend down amount. That has to be spent down so that the ill spouse has $2,000. The healthy spouse has no more than this $148,620. And then the ill spouse is eligible for Medicaid. Okay, so, we're talking a lot about the couple. If you go in and you're single, widowed, or divorced, then a lot of these rules don't apply. You have to, you can only have $2,000, period, the end. So there's all kinds of strategies you can use for a single person, but a lot of people come in, they're married, and I've been giving you like an overview of what you can do with a married couple. So a married couple comes in and they own a house. This is like very many people that come in, and the community spouse, you transfer the house to the community spouse. They can keep a house, one house, the principal residence, one car, and that $148,000. And the ill spouse can keep $2,000, and everything else is part of the spend down. That Medicaid says it's spend down. If people think, okay, the only thing I can do with it is I got to spend it down, but no. I mean, you don't have to spend it down on a nursing home. You can do other things with it. time is passing, I realize this. Okay, so I'm gonna just give you an overview of these kind of things. There's different, I listed a bunch of trusts here. Some of the trusts, you transfer money to the trust and it's considered a gift and there's 5 years. Some people walk in the office and they're not ready for long-term care. They just are ill and they know that, it's going to reach a point where they're not going to be able to live on their own anymore. They're going to need care. Other people come in and they need immediate assistance. In other words, they got to be eligible for Medicaid like yesterday. So it all depends on who's coming in, their marital status, and what condition they're in to determine what you do. So some of these trusts, like this trust, if you fund an income only trust, you have to wait for 5 years before you're eligible. This is another kind of trust. There are different requirements, but it's not an exempt transfer. The sole benefit trust, you could be eligible immediately with this kind of a trust. Or retained interest trust. This is the kind of trust where you put a house in, or low basis securities, where you need to step up in basis when the owner passes away. Pooled trust is one of the usually the charity sets it up. Okay, and then the special disabled adult children. There's lots of people with disabled adult children, and they're provided for under these rules. A lot of the transfers can be made to disabled adult children outright, or you can make transfers to children they're called sole benefit trust or special needs trust. It all depends on what the child has. Sometimes people walk in and they have a disabled adult child and they're receiving needs-based benefits like SSI. They may be getting Medicaid themselves, the child. So how do you transfer anything if the child has assets? They're not eligible for a lot of the benefits they may be receiving. So you have to set up a special needs trust for them.